Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana on this beautiful Easter Sunday, and I do mean beautiful. And I figured that I'd take this opportunity to bring all of our viewers up to speed on 5 Louisiana State Police related lawsuits. We're going to cover all 5 of them. We'll do so in somewhat of a rapid fashion, except for the first one. We'll spend a little bit more time on it. And I do that because many times I'm sure people say, well, gee, I remember hearing that this lawsuit was filed a long time ago. What's come of it? And, you know, there can be a rather protracted period to go by before we can give you any kind of a meaningful update, because anybody who's familiar with the legal process knows, as they say, the wheels of justice grind slowly, and as is the case in civil matters, typically they will drag on and on and on and on and on. And if you want proof of that, just ask Murphy Painter, whose civil lawsuit has now dragged on, I don't know, something like about 6 or 7 years, and yet we're not even to the point of the defendant having to answer the lawsuit. And I've attended about 20 approximate hearings for it. There'll be another one upcoming soon. But I said that to say this, you may not hear anything from us about an update on lawsuits, but it's not because things aren't going on. It's just that it takes a lengthy time for these things to work their way through the system. It's just the nature of the beast. All right, when we give you each lawsuit, if we've covered it in the past, we're going to give a direct link to the original article, and now I'm going to give you an update. We'll begin with one of the more recent lawsuit regarding it. When I say state police, it'll be a state police related entity, okay, not necessarily where state police is a direct defendant in the matter. And the first one would be the Shelley Sebastian matter. We brought that to you only about a couple of weeks ago, and we'll give you a link to that article. There was a hearing held on April the 8th, Monday, April the 8th. And, you know, I mentioned in that article that we did before that prevailing on a writ of mandamus is extremely difficult. There is extremely rare for a court to grant a writ of mandamus. Having said that, and in this case, the judge did not grant the writ of mandamus, the judge being Tim Kelly in this case, but I will tell you that he uttered the words that he was quite disturbed at some of the things that had been testified to at that hearing, and especially with regard to discrepancies that may exist between originals and subsequent reversions of public documents. And he also stressed that he wanted it known in no uncertain terms, and he even cited a case. It was the Mary Roper incident. She used to be the parish attorney, and he was the judge who got that case. And he emphasized that he did assign penalties against a number of the Metro Council members. I believe it was, I think it may have been $5,000 each. He assessed penalties against 4 or 5 Metro councilmen, except C. Denise Marcel, whom he singled out as having been basically bowed up and did not, and intentionally wouldn't conform to the public records request, and I believe he assessed her $20,000. In fact, I know he did. C. Denise Marcel is currently a state representative, and she used to be on the Metro Council. But at any rate, and I'm sure, who knows who ended up paying the $20,000, probably us, but at any rate, so that hearing was held on the 8th of April, and as I said, the writ of mandamus was denied. But I want to just bring out a little bit of testimony that transpired, and that, you know, most of what took place in there, in that hearing surrounded how the hiring of the DPS security for Ms. Sebastian's return to work on March the 11th came about. And the executive director of the State Police Retirement Board, by the way, that is the defendant in this matter, the State Police Retirement Board, the executive director, Erwin Phelps, was placed up on the witness stand, and when he was asked about how all this came about, he said everything was oral. There was nothing in writing. Well, that's not true, okay? And in a public records request that we made, we're going to provide you with the email wherein all of the provisions for hiring, or I'm going to having, strike the word hiring, let's replace it with having security. There's no evidence any payment was made for this. But at any rate, as you can plainly see from the email that we're going to put right below this post, there was considerable discussion in the form of email chains about security being there on the 11th. A gentleman named Gerald, who was responsible for these type of details, is the email going back and forth with Miss Gann. Miss Gann said, I'd have coffee ready. You'll see 5 different officers that were to be assigned for each day of the week upon Miss Gann's return. Now, I will say this. Erwin Phelps' name was not in that email, okay? So it's entirely possible that he may have genuinely believed at the time he was on that witness stand that everything was all oral. That's possible because he's not on that email chain. So giving Mr. Phelps the benefit of the doubt, which I try to do with anybody, and some people have said I've been overly generous to Mr. Phelps. And just as a quick aside, Mr. Phelps and I worked together 32 years ago at Ambank. That is a long, long time ago. And I thought well of him then. I'm just going to be blunt about it. And so did a number of other people in the bank. And all I can say is if some of the things that are being depicted of Mr. Phelps in his current status are true, and will gradually, as this thing makes its way through the court system and through the civil service appeal system, we'll probably gain light as to whether some of them are true or all of them may be true. But if that is the case, he's a very different Erwin Phelps than I knew 32 years ago. And I'll just let it go with that. But at any rate, Mr. Phelps on the witness stand said that when he was asked, well, how did the hiring of this, strike the word hiring, how did the providing of this security for Miss Sebastian's return to work come about? Well, Mr. Phelps said that, and he paused for a long time before he answered this question, which I think was a tip-off that it was going to be challenging to answer it. But what he said was there were 2 Louisiana State Police troopers that met privately with him in his office. But again, he stressed everything was all oral. Now, Mr. Phelps says that the desire for security originated from LSP. All I can tell you is tell you what he said on the witness stand. He said that the desire for security originated from LSP. And as I just told you, he said he met with 2 LSP troopers privately in his office, and it was deemed that security would be appropriate. The attorney for Miss Sebastian did not ask who were these 2 troopers. I wish she had. I'm sitting there on a bench saying, ask him who they were. And I'm not faulting her on that. At any rate, I'm just going to point out that we know there are 2 troopers, well, there are actually 3 troopers, but these are the 2 most likely. Common sense would dictate it. You have Frank Besson and Kevin Marcel, who both serve on that board as the chairman and vice chairman, respectively. So I think common sense would dictate those were probably the 2 who sat in that meeting. But we don't know that. The 3rd trooper who serves on that board is Jay O'Quinn. He's the president of the LSTA. I would figure he is a much, much less likely candidate to have been in on that meeting. So, but at any rate, there's no, and perhaps Mr. Phelps felt like all of this was oral. Everything he testified to was oral. But all I can tell you is we've got these emails between Miss Gann and Gerald at DPS. I had to pause because I wanted to say LSP, DPS, regarding who all was going to be lined up for this security, and so that wouldn't match everything being oral. All right. When I did the last feature, I put in there that it was going to be very interesting to see what type of leave Miss Sebastian took, because after she'd been there a couple of days, according to what was in the original petition, it was said that Mr. Phelps came to her and said, look, until we get this whole thing resolved, it would be best for you not to come into the office, thereby posing the question, well, if she's not going to come into the office and clearly then not be working, what type of leave, how are these hours going to be accounted for? You know, and as any, I think, decent attorney who goes to court would do, you already know the answer to the question before you ask it. But I did make public records requests for Ms. Gann's timesheets, and we're going to provide them to you. And they're not signed, first of all. They weren't prepared by Ms. Sebastian, okay? They were prepared by that office, and you're going to see the initials KG on there for Kimberly Gann. I was not happy with the public records request response that I got, because even though there's a legend down at the bottom which clearly discloses what type of leave is applicable for these days, they weren't there were no codes, leaving it wide open. Now, I already knew what type of leave was taken, okay? But I wanted to provide the opportunity for the retirement board to tell me what type of leave was taken. And so I made a subsequent request, and I said, look, and we're going to give you the email that I sent. I said, look, the legend is down here. I want to know what type hours Miss Sebastian took during these approximate 8 days that she was told not to come into the office, but nevertheless she is still an active employee. This was prior to her termination, which transpired, I believe, on March the 27th. The timesheet will reflect the exact date, but I believe it's March the 27th. And I got a response back, presumably drafted by, or presumably dictated by an attorney, Miss Akers, Denise Akers, I would presume, don't know that, who I was never really impressed with due to her proposal that names be drawn out of a hat. Whether it was her proposal or not, she ought to have enough common sense to know this isn't going to fly, and it violates people's ability to make comment at public meetings, and yet she went forward with it. She lost a lot of credibility in my eyes there. But the response is that I'm not going to be provided with the nature of the leave taken due to privacy matters. Well, I'm here to tell you, I wouldn't even be able to give you the number of timesheets that I've requested. In fact, we've requested a massive number of certain LSP troopers. I have them all out there. I have them all on a web page. I have the links for them. And if you want to talk about somebody in timesheets, go speak with Sandy Edmonds over at the Auctioneers Licensing Board. She will tell you how diligent I will be about getting timesheets. Never one time did they assert any such privacy. Okay, I think this is another ill-founded statement by the attorney, but I'll point all that out to say, isn't it interesting they don't want me or you, because I do these things on behalf of you, they don't want you to know what type leave Miss Sebastian took. Interesting, isn't it? And let me just ask this as a hypothetical. If someone is reporting being sick for 7, 8 days, and they're not sick, and they're ready, willing, and able to go to work, does that sound like a proper thing to do? It's a hypothetical. Or does that sound like that may be payroll fraud? It's just a question. Like I said, I always have the answer to that type of question before I ask it, and I find it very, very interesting that the retirement board avoided my question. And apparently depended upon an attorney who would say, we're not going to give that to you due to privacy issues. I think the reason you don't want to give it to me is because you don't want me knowing, or the public knowing, just how you handled this matter. All right. Sorry I took a little bit of while on that, but you know, I don't like getting those type responses. I didn't make an issue of it then, and I think I've been quite professional in the way I've handled it here on this video. And I think I've gotten my point across, and I think probably a number of folk that are viewing this would concur that we're paying someone for sick leave when they're not sick and readily admit, I'm ready, willing, and able to go to work. Okay? I define that as payroll fraud. I'll leave it to those who may be in a better position to assess than me on that. I can certainly see where Miss Sebastian would say, you know, you better not take that annual leave. She knew she was about to be fired. You You know, and you can get paid for annual leave up to 300 hours. So if it was deducted from her annual leave, well, then that would mean she would get a lower lump sum check, unless she had well over 300 hours of accumulated annual leave. And even if she did have well over 300 hours of accumulated annual leave, and I don't know the exact number of years, I think it's 3 years. If you return to state government within 3 years, all of your leave can be reinstated. It's only after, I think, 3 years that excess leave is forfeited. But at any rate, I can see where she wouldn't have wanted it to be annual leave, all right? Nevertheless, she was ready, willing, and able to go to work. So you can see the quagmire that the retirement board got placed in by saying, until we, now this is according to what was in the police, but we know she wasn't there, okay? We know she was there for 2 days under tight security, and then she's told not to come into the office, and it's put down as, well, it's put down as other leave. And they tell me you're not going to find out what the nature of that leave because there are privacy issues at hand. All right. We will be staying on top of the Sebastian matter, obviously. I think you're starting to see it's getting a little more intrigue. I'll wrap it up with regard to Miss Sebastian. There was an admission. There was a point-blank admission on the part of Miss Gann that yes, she was provided with a satisfactory performance appraisal only a couple of months before she was terminated for the purpose of facilitating a pay raise, which I seem is really bizarre. I don't know any other way to say it. If you think you're going to be firing someone, you give them a pay raise a few months before, but Ms. Gann did say it was jointly agreed upon that they would give her this satisfactory performance appraisal in order that she could get a pay raise. Ms. Gann said, we try to keep as happy of a work environment as we can, try to keep as many employees happy as we can. And she said that Miss Sebastian would complain about her low salary, quote, almost weekly, unquote. One last thing. I don't know what happened. Hopefully, as this thing progresses, we'll learn more about what happened for this kind of a drastic move to be made that's now going to cost an ungodly amount in legal fees, no matter how it turns out. But supposedly, the October 2018 meeting, and this was all testified to in court, Ms. Gann described the meeting as, quote, disturbing, unquote. I've gotten a copy of the tape. I've been through most of it. I failed to... If there was something disturbing about it, it must have transpired off-site. I don't hear anything that I would classify as disturbing from the meeting. Having said that, I have not finished the entirety of it. What apparently happened is there was a legislator who needed a document, and the document couldn't be provided because there were no minutes from this October meeting, and I presume it was supposed to be Miss Sebastian's responsibility to prepare the minutes. I don't know what the situation may be. I just know that they seemed very unhappy that they couldn't facilitate this legislator's desire for whatever document he wanted. It may have been the minutes themselves. I don't know. I do know there was some discussion about continuing education, and that part of that October meeting could have qualified for continuing education. So maybe, I'm speculation now, Representative Jones is a member of that committee. He was present in October. Perhaps he needed those minutes to evidence the continuing education. That's speculation. I don't know. All I know is some legislator, and it's a possibility that it may be Representative Jones because he sits on it, needed some documentation, and it couldn't be provided because there were no minutes. All right. So I'm going to let that do it for now. There are some other things that probably will come out as this whole matter progresses, but because they aren't in public record yet, and I probably won't allude to them unless they make it to the public record. But I would expect they will make it to the public record, and once they do, we'll certainly report on them. But I like to have, I'm a belt and suspenders type of guy. I like to have solid evidence of things before I report on them. Bloggers already get a somewhat undeserved reputation for not fact-checking things, and as a former fraud investigator, I like to take great pride in the fact I do fact-check. All right, I get very upset when they lump all of us into one category like that. All right, let me move on. We're going to cover the other lawsuits very, very briefly because I wanted to spend most of the time on Miss Sebastian. Kevin Sulcer is a state trooper. We have never reported on this. There's another blogger, Tom Aswell at Louisiana Voice, who did report upon the initial lawsuit. He filed a lawsuit for discrimination. If I remember right, Jill Kraft was the original attorney. She then transferred it over to J. Arthur Smith. Some of you may recall J. Arthur Smith as being the attorney representing Mr. Tingle, Brett Tingle, with regard to the alcohol and tobacco situation. I covered, and Troy Hebert, and I covered that trial in its entire, well, I gave you pretty much daily updates of what was going on because there was no other media outlet out there. I don't think Mr. Smith was overly thrilled to see me show up at what was a motion for summary judgment on the part of state police. That's where you seek to have the matter dismissed based on, quote, no issue of material fact existing in the matter. I did go attend that hearing. Richard Bourgeois, the magistrate judge, presided over it, and what he said was, and this was prior to him making his ruling, but I think it was at least I thought it was pretty clear, and I said that to several people I talked to on the phone about the hearing, which direction he was going in. He did say that it's very obvious that they wanted this gentleman named Guitro to get a polygrapher's position. There was an opening for a polygrapher. Mr. Guitro did not have the necessary schooling for it. They sent him to school, then they posted the position, and he got the position, and Sulcer asserted racial discrimination in saying this kind of thing is pandemic in state police. I don't know whether it is or it isn't. I cover state police, but I don't get into that level of minutia to know whether this is or isn't a pandemic practice. But at any rate, he wanted to assert, or he did assert, racial discrimination. The judge said that clearly there were violations of civil service procedures that took place, but he said there simply lacked there was no evidence to suggest that he said clearly they had the gentleman they wanted for the position. And I guess that may be the case more often than not. You know, it's kind of like the whole Caleb Reeves situation about getting the detective position. I'll briefly allude to that in a moment. But at any rate, he said it's not looking like you meet the bar, and I'm paraphrasing. It's not exactly what the judge said, but it's close. With regard to racial discrimination, he then advised that if it was at all possible to settle this matter, it may be in both parties' best interest to do so. Because I think he was kind of leaving a small window open that, hey, I'm not totally saying I'm going to throw this thing out. But in the end, he granted the motion for summary judgment. I think he was dropping a hint to Sulcer in saying that, hey, if y'all can settle this matter, it's like, hey, if you can get a couple of nickels on the dollar on this thing, get it, because otherwise you're going to get a goose egg. And anyway, we will give you the document. The judge did grant the motion for summary judgment, so that's it for the Kevin Sulcer matter. Let's move on to Kathy Durbin. The most thought of phrase when you think of that on the material we presented is the governor's office having supposedly, according to Ronnie Jones, told her to shut the F up, as would be predicted. Now in this instance, we're talking about the State Police Commission as the defendant. And remember, I said all of these things would be LSP related entities. With regard to the State Police Commission, they asserted a peremptory exception of no cause of action, and in the initial video, you know, when I put in their exception when they asserted it, I did say that they probably have a pretty strong argument here that it was not the commission who made these appointments that didn't follow the Constitution. That would be the gentleman that presently occupies the governor's mansion, aka John Bell Edwards. And that's exactly what Judge Morvan said. He said there are a whole bunch of allegations that are made in here that took place, but none of them can be tied directly to the State Police Commission, an act that it did, all right, as a body. And so He said he gave the obligatory 30 days to amend the petition. He granted the peremptory exception. Whenever you grant a peremptory exception by statute, you give 30 days to amend the petition in an attempt to cure that exception. Ms. Durbin has filed an amendment to the lawsuit in an attempt to cure that peremptory exception. We will provide you with that document as part of this update. The ball is now in the Police Commission's court. It looks like things are going a little dark on me, but the ball is now in the Police Commission's court. My thought is they're obviously going to reassert the peremptory exception. One of the defense attorneys even said, Your Honor, I don't see how they cure this. But Judge Morvan said, I don't agree with that statement. So obviously in the judge's mind there is some way to cure this. And so my guess is, having followed numerous trials, is it's kind of like a football analogy, and you got the ball all the way down to the 3-yard line. You're not just going to walk away and say, we'll settle for overtime. My guess is they're going to reassert the peremptory exception, in which case there will be yet another hearing. That's what I mean about these things dragging on and on and on and on. And then if the judge deems that the petition still does not state a valid cause of action, then there's little left to do other than appeal to the First Circuit, where the chances probably may be somewhat remote. So we'll just have to wait and see, but that's where we are on that. So again, the peremptory exception was granted. The petition has been amended. We will give you the link for the filing to amend the petition, and we are now waiting to see what the commission does. If the commission does not reassert, and I view that as highly unlikely, then it will just proceed on. There will be discovery and the whole 9 yards. I don't look for that to happen. I certainly look for the police commission to reassert its cause of action. That's just what you do, especially when it was granted and the defense attorney says, Your Honor, I don't see a way to cure this. Either he would be awfully impressed with Ms. Craft's amended petition, or they would reassert. That's why I'm telling you that my money would be on it being reasserted. Let's move on to Calvin Braxton. He is suing the Louisiana State Troopers Association. And just very briefly, that matter continues to go through what is called the discovery phase. There will be a number of, or have been, correct that grammar, there has been a number of troopers that have been subpoenaed for providing their deposition. Oh, do I wish I could sit in on those depositions or have an ability to hear how they go. Because the reason I say that is somebody, I don't like to use this word, but it's true. Somebody's lying, okay? The two scenarios, the one that Calvin Braxton presents and one that the state troopers that are involved in this, and I'm talking about, the Troopers Association, and particularly a gentleman named Oliphant, Jay Oliphant, okay? And what I'm going to do is copy and paste. When we did the Caleb Reeves situation, we devoted a significant section of that to Mr. Braxton's deal. So I'm going to copy and paste that under this Braxton update. Because Mr. Braxton contends that Oliphant's report is a complete and utter falsehood, almost from beginning to end, if not from beginning to end. I will say this, I do find it ironic that Lieutenant Colonel, because I believe that's now his position, he's one of only about 5 to hold such a position, second in line to the Colonel himself, and I believe there are only 5 such positions. He got a double promotion within a very, very short period of time. One could conclude that was a way of saying thank you for ridding us of such a problematic state police commission member. That's just one train of thought. I find it ironic that somebody who would make a public post on Facebook that I'm told is even against policy, where he says, I'm scared of this businessman, and you're going to reward him with a double promotion? to the second highest rank in state police? I hope that the lying end is, it better be on Mr. Braxton's side, because if it's not, you talk about looking really, 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 really bad. State police will look unbelievably bad if it can be substantiated that Mr. Braxton's version is accurate. We're going to also give you the little interview Jill Craft did, wherein she says this is what happened. And when she was asked by Katie Moore, can you prove that? She said, we'll find out, won't we? And we will find out. And that's an update on the Braxton situation. But boy, I would, if they issued tickets for those depositions, I would buy a book to everybody who's being deposed. I would buy a book of tickets, and I wish I could sit on this so bad. And I hope we're able to gain access to what all takes place in these depositions, because I think they ought to be incredible revelations if they're not totally evasive and suddenly nobody can remember anything. All right, last but not least, we have the State Troopers Association. So they get the unique rule of being both plaintiff and defendant here, because as you may remember, the State Troopers Association is suing the State Police Commission over this whole issue of being able to make political contributions. They say the commission is violating its constitutional rights in not permitting it to make these contributions. On April the 9th, I believe it was, the State Police Commission asserted a dilatory exception based on prematurity. They are basically saying that you've put the cart before the horse here. We're going to need for this to have actually taken place before the constitutionality of it can be addressed. And since you file this prior to any such instance of any such political contribution, now let me just say this, dilatory exceptions are mainly meant to just drag things out. That's usually their purpose. So we're going to provide you with a dilatory exception. There's not been any other activity on this suit since it was filed, I think back in August or September of last year. See, I'll tell you about how things can grind very slowly. But so they are asserting a dilatory exception of prematurity based on the fact that this hasn't actually happened, so no one's in a position to challenge whether or not their constitutional rights have been violated. Alrighty, folks, that wraps it up for the 5 LSP-related litigations. For those of you who did stick around for all 5, I know this was not the shortest video. I know oftentimes many people I don't get that much viewership on videos, but you know, that's okay. As you've noticed, I come to a park for this, and I guess I'll take the approach that even if only 1 or 2 viewers do it, I at least had the frogs, I had the geese, the ducks. You know, you may have heard of a few of them in the background because it is a holiday and they like to be fed, and I forgot to bring the bread, and when I first walked up, they weren't happy, okay? But nevertheless, when they ascertained that I didn't have bread with me today, I assume will forgive me, and they went on back about their enjoyable swimming and frolicking, because it is one more beautiful Easter Sunday. I hope everyone enjoyed their Easter Sunday, and we will look to bring you another Sound Off Louisiana feature in the very near. There comes one of them back. We'll look to give you another Sound Off Louisiana feature in the very near future. Thank you once again.